All right, welcome along, and this is today's final reading of the Kahnawake Cannabis Control Law. We'd like to thank our local media for being here to witness the event. This is part of the community decision-making process. It's one of the final stages as we've gone through quite a bit of work to get to this point, and at this point we'd like to introduce I guess Rhonda Kirby, who has been the lead portfolio chief on this file. Rhonda?
Good morning, everyone. As Joe said, we're very pleased that we're at this point in the process, and I'd like to thank the KLCC for getting us through this. We've been working on the idea of a draft law for well over 2 years, and we're very happy that we're at this point.
And with that, we'll get right on to the task at hand. And it's not necessarily the most exciting part of the process, but it is part of it, so we'll get to it right away. And I'll start off the Kahnawake Cannabis Control Law. This is a Kahnawake law respecting the cultivation, processing, distribution, sale, possession, and use of cannabis within and from the territory. Section 1.
The short title, the law, will be cited as the Cannabis Control Law.
Section 2, Jurisdiction. The Kahnawake of Kahnawake, as part of the Mohawk Nation and the Six Nations Confederacy, and respecting the principles contained within the Constitution of the Six Nations Confederacy, are and have always been sovereign peoples. 2.2. The Kahnawake of Kahnawake have consistently and historically exercised ultimate and exclusive jurisdiction over the territory. 2.3. The Kahnawake of Kahnawake have existing, inherent, and inalienable rights, which include the right of self-determination, the right to promote and control economic development, and the right to preserve peace, power, and righteousness within the territory. 2.4. The aforementioned rights of the Kahnawake of Kahnawake have been recognized and affirmed in the domestic laws of Canada, including the Constitution Act 1982 and other federal and provincial legislation. 2.5. The aforementioned rights of the Kahnawake of Kahnawake as Indigenous peoples have been recognized and affirmed in international covenants and declarations, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and the United Nations Declaration on the Rights of Indigenous Peoples. 2.6. As cultivation, processing, distribution, sale, possession, and use of cannabis has a significant impact on socio-economic development, health, safety and peace, power and righteousness within the territory, the Kahnawake of Kahnawake have the ultimate and exclusive right and jurisdiction to regulate and control cannabis within the territory. 2.7. Given that jurisdictions surrounding Kahnawake are creating legislation that directly impacts the well-being of our community, the Kahnawake of Kahnawake have the obligation to regulate and control cannabis in a way that protects and preserves the best interests of our community. 2.8. The Mohawk Council of Kahnawake, as a governing body in and for the territory, has the power and authority to enact this law on behalf of the Kahnawake of Kahnawake.
3. Application. 3.1. This law applies to A. All activities related to the cultivation, processing, distribution, sale, possession, and use of cannabis within, into, and from the territory, and B. All persons and business entities situated or found within the territory. 3.2. This law and regulations may apply to Delaronde territory to the extent that it is authorized in whole or in part by resolutions of both the Mohawk Council of Kahnawake and Mohawk Council of Kanesatake. 3.3. Laws of general application will continue to apply to the extent they are not inconsistent with this law or the regulations.
Section 4, Prohibition. Unless authorized by this law or the regulations, the cultivation, processing, distribution, sale, possession, and use of cannabis within and from the territory is prohibited. For greater certainty, a license issued by a regulatory authority outside of the territory has no validity within the territory unless the license holder has also been authorized under this law or the regulations.
5, cooperation. 5.1, to ensure the purpose of this law and the regulations are fully realized, the Kahnawake Cannabis Control Board will liaise regularly and cooperate with Cannabis Health and Safety Committee and any other appropriate agency.
6. Harmonization. 6.1. This law may serve as a basis for the harmonization of laws and regulations concerning cannabis in other jurisdictions and for cooperation and mutual assistance between the Kahnawake Cannabis Control Board and other First Nations and other regulatory and law enforcement agencies. However, this law and the regulations are not dependent on the approval of or cooperation from any other governmental body or agency. 6.2. For greater certainty, the foregoing section 6.1 is not intended to and does not in fact affect, compromise, or diminish the authority of internal agencies such as the Kahnawake Cannabis Control Board, the Kahnawake Peacekeepers, and any other regulatory or law enforcement agency empowered under Kahnawake law. 6.3. The requirement section in 16.1 of this law to hold an equivalent license issued by Health Canada will remain in force until such time as Kahnawake establishes a public health agency that has a capacity and standards comparable to Health Canada regarding the issuance of cannabis-related licenses in compliance with the criminal laws of general application.
7. Purposes. 7.1. The purpose of this law are to A. Protect the health and safety of the Kahnawake of Kahnawake and other persons found within the territory and, in particular, to protect the health of young persons by restricting their access and exposure to cannabis and cannabis byproducts. B. Protect the jurisdictional integrity of the territory by ensuring mutual respect and cooperation in relation to jurisdiction, economic advancement, and enforcement of Kahnawake's domestic affairs. C. Facilitate a regulated and controlled cannabis industry that will promote and enhance socio-economic development, fiscal self-sufficiency, and tangible benefits for the Kahnawake of Kahnawake. D. Provide for the legal cultivation, processing, distribution, sale, possession, and use of quality-controlled cannabis within and from the territory. E. Deter illicit and illegal activities in relation to cannabis, including but not limited to 1. Preventing cannabis from being diverted into the illicit or illegal market. 2. Preventing illicit or illegal cannabis from entering the source of supply of the legal cannabis market through appropriate sanctions and enforcement measures. And F. Balance the interests of Kahnawake community members who, on the one hand, are opposed to legal cannabis in the territory with the interests of community members who support the regulated cultivation, processing, distribution, sale, possession, and use of cannabis in the territory.
Definitions, section 8. 8.1, for the purposes of this law and the regulations, accountable means having a duty to provide complete and accurate information, provided the information is not subject to privilege or confidentiality. Approved agent means a person or persons approved by the board to carry out any of the functions set forth in this law or the regulations on behalf of the board. Arm's length means having authority and responsibility to make the decisions and take the actions as provided for in this law. Board means the Kahnawake Cannabis Control Board. Cannabis means a plant that belongs to the genus Cannabis and includes A. Any part of a cannabis plant, including the phytocannabinoids produced by or found in such a plant, regardless of whether that part has been processed or not, other than a part of the plant referred to below. B. Any substance or mixture of substances that contains or has on it any part of such a plant. And C. Any substance that is identical to any phytocannabinoid produced by or found in such a plant, regardless of how the substance was obtained, but does not include D. A non-viable seed of a cannabis plant. E. A mature stalk without any leaf, flower, seed, or branch of such a plant. And F. Fiber derived from a stalk referred to above. And G. The root of any part of the root of such a plant. Committee means the Cannabis Health and Safety Committee. Consumer means an individual that purchases cannabis for personal use. Council means the Mohawk Council of Kahnawake. Cultivate means to grow, propagate, or harvest any cannabis plant or any other living thing from which cannabis may be extracted. Cultivator means the holder of a valid standard cultivation license or micro-cultivation license. Dispensary means a commercial facility located within the territory that is operated by the holder of a dispensary license. Distribute or distribution in respect to cannabis means giving, transferring, transporting, sending, delivering, providing, or otherwise making available in any manner, whether directly or indirectly, and includes offering to distribute. Distributor means the holder of a valid distribution license. Family member means a spouse, parent, child, or sibling. Individual means a single human being. Kahnawake, Mohawk Territory of Kahnawake, or territory means A, the lands presently under the control and jurisdiction of the Kahnawake of Kahnawake, including the lands referred to by the Government of Canada as Kahnawake Indian Reserve Number 14. B, any and all lands that may be added to the lands now under the control and jurisdiction of the Kahnawake of Kahnawake through the negotiation and resolution of land grievances. C, any and all lands that may be added to the lands now under the control and jurisdiction of the Kahnawake of Kahnawake as a result of any other means. D, lands which are returned to Kahnawake as lands within the meaning of subsection 91(24) of the Constitution Act 1967. E, the water and waterways under the control and jurisdiction of the Kahnawake of Kahnawake. F, lands that Kahnawake has not relinquished or ceded. License means a license issued by the board. License holder means the holder of a valid license. Kahnawake of Kahnawake, when used in the singular, means a person registered on the Kahnawake of Kahnawake registry as a member of the community of Kahnawake, and when used in the plural, means all persons making up the community of Kahnawake. Ungwehue means an indigenous individual. Person includes an individual, corporation, partnership, limited liability company, and any other business entity recognized under the laws applicable within the territory. Possess, in respect to cannabis, means to have cannabis in a person's personal possession or knowingly have cannabis in the actual possession or custody of another person, or has cannabis in any place, whether or not that place belongs to or is occupied by the person for the use of the person or any other person. Prescribed legal age means the full age of 21 years or such other age as is provided in the regulations. Process in respect to cannabis means the production, packaging, and labeling of cannabis products. Processor means the holder of a valid standard processing license or micro processing license. Public area means the buildings and areas defined by the regulations. Regulation means any regulation enacted by the board under this law. Sell or sale means to transfer ownership in exchange for money or something of value, and includes offer for sale, expose for sale, and have in possession for sale. Jorodo territory means the land described as Doncaster Indian Reserve Number 17, and use in respect to cannabis means to smoke, vape, inhale, ingest, absorb, or otherwise consume.
Section 3(9), permitted activities. 9.1, subject to the section 24.3, a person who has attained the prescribed legal age is permitted to possess cannabis for his or her personal use, provided that A, the cannabis has been acquired from a dispensary or from a facility that is licensed by Health Canada, and B, the total amount possessed at any given time does not exceed the amount prescribed by the regulations. 9.2, notwithstanding the foregoing, where a person is a medical patient and holds a valid prescription from a licensed medical practitioner, the terms of the prescription will supersede this law and its regulations, but solely for the purpose of the person's medical treatment. 9.3, notwithstanding the foregoing, no person is permitted to smoke or vape cannabis in a public area, including a school zone, or in any building or area that is designated by the owner to be a no smoking or no vaping zone. 9.4, No person is permitted to use or be under the influence of cannabis when operating a motor vehicle, and offenders may be charged and prosecuted under the applicable penal or criminal laws of general application.
Section 4, 10, Kahnawake Cannabis Control Board. 10.1, there is established a regulatory body to be known as the Kahnawake Cannabis Control Board for the purpose of regulating, enforcing, and administering this law. For greater certainty, the board will not be a public policy-making body.
11, general mandate. 11.1, the board will administer this law in the best interest of the Kahnawake of Kahnawake and in accordance with the highest principles of health, safety, security, honesty, and integrity.
Section 12, duties and responsibilities. 12.1, in addition to any other duties and responsibilities that may be provided to it in this law, the board will A, issue, suspend, and revoke the licenses provided in this law and the regulations. B, regulate, monitor, and inspect all the premises and activities of license holders. And C, make any decisions and take any actions as is necessary to fulfill purposes of this law.
13, structure of the board. 13.1, the board will be accountable to but will function at arm's length from the council. 13.2, the board will be composed of three members selected and appointed by the council from the list of eligible persons who have applied for this position. 13.3, to be eligible to be selected and appointed to the board, a person must A, be Kahnawake of Kahnawake, B, have attained the full age of 21 years old, 3, be a resident within the territory, D, not have any interest in a private entity that has applied for or has been granted a license, E, not have a family member that has any interest in a private entity that has applied for and has been granted a license, and F, have no criminal conviction for the indictable offenses or have received a full pardon from any such conviction. 13.4, subject to early termination in accordance with this law, a board member's term of office will not be less than 2 years and not more than 3 years. Wherever possible, council will stagger board members' appointments to ensure continuity and consistency. 13.5, upon expiry of the board member's term of office, subject to the other provisions of this law, the member is eligible to be reappointed for another term of office. There is no limitation on the number of consecutive term of office of a member may serve. 13.6, council will ensure that persons to be appointed as board members are mature, responsible, and wherever possible have experience with regulatory matters or participating on boards and or commissions. 13.7, the board will employ the support staff and retain the professional assistance that is required to fulfill its mandate. 13.8, board members and staff will undertake all necessary training to enable them to fulfill their respective mandates more effectively and efficiently. 13.9, the board will, by a majority vote, appoint one of its members as chairperson. The chairperson will preside over meetings of the board and will ensure the board follows the principles and procedures provided in this law and the regulations. 13.10, council may, for reasonable cause, remove a board member from the office prior to the expiry of his or her term of office. 13.11, a board member may resign from office prior to the expiry of his or her term of office by giving notice to the board and to the council at least 60 days prior to the date on which the resignation is to be effective. 13.12, in the event a board member is removed, resigns, or is unable to continue performing his or her duties for any reason, council will appoint a new board member within 30 days of such other period of time or such other period of time that is necessary to ensure the board always has 3 appointed members. 13.13, council will provide the board with an annual budget, the amount of which will be adequate to ensure the board can satisfy its duties and responsibilities under this law. 13.14, licensing fees and amounts collected by the board will be submitted to council and will be used to offset the board's annual budget. 13.15, members of the board may be remunerated for the time required to provide the services associated with their offices as determined by council. 13.16, the board will obtain, implement, and maintain such software, systems, networks, and database as the board may require to fulfill its mandate.
14, board meetings. 14.1, for the purpose of conducting a meeting and making decisions, a quorum of not less than 2 board members must be present. 14.2, to be considered binding and enforceable, decisions of the board must be approved by a vote of at least 2 board members. 14.3, the board will meet at the call of the chairperson or a majority of its members, but in any event will meet at least once every 30 days. 14.4, whenever possible, the board will participate in board meetings in person. However, with the permission of the other board members, a board member may participate in a meeting via telephone or other electronic means. 14.5, notice of a board meeting with particulars of the agenda will be provided to all board members not less than 5 days prior to date of the meeting. The board may, in its sole discretion, waive this requirement for any particular meeting. 14.6, board meetings or portions of board meetings may, at the sole discretion of the chairperson, be open to the public or may be conducted in camera. 14.7, the board may adopt such operational policies as it deems appropriate for internal functions and procedures.
15, Cannabis Health and Safety Committee. 15.1, there is established a standing committee to be known as the Cannabis Health and Safety Committee. 15.2, the committee's members will be confirmed by council and will include 1 representative who must meet the eligibility criteria of section 13.3 selected by each of the following organizations: A, Mohawk Council of Kahnawake; B, Kahnawake Memorial Hospital Center; C, Kahnawake Sokotia de Genhos Community Services; D, Kahnawake Public Safety Unit; and E, any other appropriate agency. 15.3, the committee will also include a Kahnawake of Kahnawake who meets the eligibility criteria of section 13.3 selected by a vote held within the community of Kahnawake. 15.4, the committee will on a continuing basis A, monitor the impacts of this law and the regulations on the health and safety of the Kahnawake of Kahnawake; B, make recommendations to council or the board for amendments to the law or the regulations that the committee finds appropriate to minimize the harms of cannabis use within the territory. 15.5, council will provide the committee such funding and resources as is required for the committee to fulfill its mandate.
Section 5, 16, licenses. 16.1, no person may conduct any commercial cannabis activity within or from the territory without holding both an appropriate license issued under this law and the regulations and an equivalent license issued by Health Canada where applicable. 16.2, the board may issue a restricted number of licenses in the following categories: A, standard cultivation license; B, micro cultivation license; C, standard processing license; D, micro processing license; E, distribution license; F, dispensary license; and G, such other license category that the board may create by regulation. 16.3, a license holder may hold a license for more than one category. 16.4, notwithstanding any other provisions of this law or the regulations, a standard cultivation license and a standard processing license will only be issued to an entity in which council or an entity created by council on behalf of the community of Kahnawake has an ownership interest to ensure a community-wide benefit. 16.5, a valid standard cultivation and micro-cultivation license will permit the license holder to cultivate cannabis and sell the cannabis to the holder of a valid standard processing license or micro-processing license. 16.6, a valid micro-cultivation license will permit the license holder to conduct small-scale cultivation of cannabis plants and to produce cannabis seeds, cannabis plants, fresh cannabis, and dried cannabis for the purposes of sale to the holder of a standard cultivation license, a standard processing license, a micro-processing license, or for export off the territory to a processor or retailer who holds a valid license issued by a regulatory authority in the jurisdiction in which the product is being sold. 16.7. The holder of a standard cultivation license, a micro-cultivation license, a standard processing license, a micro-processing license, or a distribution license must not sell cannabis directly to a consumer. 16.8. A valid distribution license will permit the license holder to distribute cannabis within the territory for the purpose of sale by the holder of a dispensary license. 16.9. To effect distribution of cannabis outside the territory, the holder of a distribution license may also be required to obtain a license from a regulatory authority in the jurisdiction in which the cannabis is being distributed. 16.10. The holder of a distribution license must obtain cannabis only from the holder of a standard cultivation, a micro-cultivation license, a standard processing, or a micro-processing license. 16.11. A valid dispensary license will permit the license holder to sell cannabis to a person who has attained the prescribed legal age from a dispensary located within the territory. 16.12. All license holders must comply with the provisions of this law, the regulations, any conditions to which the license may be subject, and all other laws, regulations, and policies that are applicable within the territory, including but not limited to Mohawk Self-Insurance Program and the Kahnawake labor regime. 16.13. All licenses will be for a fixed term and may be revoked, amended, suspended, or extended as the board in its sole discretion deems appropriate. 16.14. A license is not valid unless and until any licensing fees and mandatory community contributions prescribed by the board have been paid in full. 16.15, license holders will, in recruiting, training, and hiring employees, give preference to qualified Kahnawake of Kahnawake in all job categories, particularly management positions. 16.16, subject to the requirements for each license category, the only persons eligible to apply for a license are A, a natural person who one, is a Kahnawake of Kahnawake, 2, has attained the full age of 21 years of age, 3, is a resident within the territory, and 4, who has no criminal conviction for an indictable offense or has received a full pardon for any such conviction. B, a band empowered entity, corporation, or partnership that is wholly owned and operated by one or more natural persons, each of who, 1, is a Kahnawake of Kahnawake, 2, has attained the full age of 21 years old, 3, is resident within the territory, and 4, has no criminal conviction for an indictable offense or has received a full pardon for any such conviction. E, a band-powered entity, corporation, or partnership in which the council and one or more other business entities share a commercial interest. 16.17. Notwithstanding the foregoing section, if the board determines that it is appropriate from a regulatory perspective to do so, it may issue a standard cultivation license and a standard processing license to an entity that is located outside the territory, as long as the board is satisfied there is a benefit to the community of Kahnawake for doing so. 16.18. No person is eligible to apply for or hold a standard cultivation license, a micro-cultivation license, a standard processing, or a micro-processing license unless the facility from which operations are intended to be conducted has been inspected, certified, and licensed by the health and safety authorities designated by the board, which may include Health Canada officials. And 16.19, in consultation with the Health and Safety Committee, the board may at any time and in its sole discretion limit the number of licenses that are issued in any category.
17, dispensary licenses. 17.1, the board will not issue or continue a dispensary license to a person who intends to sell cannabis from a dispensary that is located, A, where the location or proposed location of the dispensary is in a building or an area that is easily accessible by persons under the prescribed legal age, and other such buildings or areas that may be defined in the regulations, or B, wherein in the sole discretion of the board, the proposed location of the dispensary of the dispensary is likely to disturb or endanger the community of Kahnawake. 17.2, the holder of this dispensary license must not sell, barter, give, or exchange A, cannabis to a person who has not attained the prescribed legal age, B, cannabis to any person who is not a consumer, C, to any person an amount of cannabis that exceeds the amount prescribed by the regulations, and D, cannabis that is not obtained from the holder of a distribution license.
Section 6, 18, standards and testing. 18.1, the board will enact regulations to establish standards and testing procedures to ensure that all cannabis cultivated, processed, distributed, and sold within the territory is consistently and reliably high quality. For greater certainty, the board will ensure its regulations are consistent with the standards and testing procedures promulgated by Health Canada. 18.2, the board may engage approved agents, which may include representatives of Health Canada, to assist and advise the board in relation to A, the preparation of appropriate standards to be followed by facilities that intended to be used for the purpose of cultivating or processing cannabis, B, inspections and certifications of facilities, equipment, and materials used by facilities for the purpose of cultivating or processing cannabis, C, testing of cannabis cultivated or processed by facilities licensed under this law and the regulations, and D, the storage and handling of cannabis.
19, packaging and labeling. 19.1, it is prohibited for a license holder to sell cannabis in a package or with a label that does not conform to the requirements of comparable requirements established by Health Canada. 19.2, the labeling of cannabis packages sold by a license holder must include A, the tetrahydrocannabinol THC or cannabidiol CBD content, B, a list of all ingredients, particularly of the cannabis products, is edible in the cannabis product, C, a control or batch number to enable tracking of the processing, completion date, and location of a cannabis product, and D, such other information as may be provided in the regulations.
Section 20, price controls. 20.1, to preserve the economic viability of the cannabis market in the territory, the board will establish minimum and maximum prices for which any cannabis product can be sold. A, by a cultivator and processor to a distributor or a dispensary. B, by a distributor to a dispensary. And C, by a dispensary to a consumer. 20.2, the amounts of the prices established by the board for cannabis products A are in the board's sole discretion but will take into consideration the market prices of cannabis being sold off the territory. B, may be varied from time to time, and C, will be communicated to each license holder.
21, point of sale, non-ungwehongwe royalty. 21.1, to preserve fairness in the cannabis market within and outside the territory when purchasing cannabis from a dispensary, non-ungwehongwe consumers must pay an additional point of sale royalty equal to a percentage of the purchase price to be established by the board. For greater certainty, ungwehongwe consumers are exempt from paying the point of sale royalty. 21.2, the holder of a dispensary license must A, charge and collect the point of sale fee on all sales to non-ungwehongwe consumers, and B, remit all point of sale fees to the council on a monthly basis. 21.3, council will use the amounts of point of sale fees collected under this law to help fund underfunded projects, community initiatives, and other socio and economic projects within the territory, including drug prevention and education initiatives.
22, mandatory community contributions. 22.1, unless the council determines that the license is for the purpose of operating a socio-economic project, in addition to any licensing fees prescribed by the board, license holders must remit to the council a mandatory community contribution, the amount and frequency of which will be determined by the board in consultation with the council. 22.2, a license is not valid unless and until all mandatory community contributions have been paid in full. 22.3, Council will use the amounts of mandatory community contributions collected under this law to help fund community initiatives within the territory.
Section 7, 23, Regulations. 23.1. The board may enact such regulations it considers necessary to implement the provisions of this law, including regulations respecting A, the creation of new categories for licenses that may be issued under the regulations, which will include, but not be limited to, permitted activities, prohibitions, and application requirements and procedures. B, the forms to be used and processes to be followed to apply for a license. C, background and security investigations and credential verifications of owners, directors, and key persons associated with applicants and license holders. D, background and security investigations and credential verifications of personnel, staff, and companies contracted to conduct business with or on behalf of a license holder. E, the amount of application, annual, and other fees to be charged for licenses. F, in consultation with council, the amount and frequency of mandatory community contribution payments. G, the days and hours during which a dispensary may operate. H, the type of cannabis products that a dispensary may sell. I, the requirements to which the holder of a micro cultivation license will be subject, including but not limited to quality assurance standards, plant count, size of growing area, total production, and gross revenue. J, limiting the total number of licenses that will be issued. K, in consultation with council, modifying the prescribed legal age that will apply for all purposes of this law and the regulations. L, establish the maximum amount of cannabis that a dispensary can sell to a consumer within a specified period of time. M, the composition, strength, concentration, potency, purity, or quality, or any other property of cannabis or any class or type of cannabis. N, standards and testing procedures to ensure that all cannabis cultivated, processed, distributed, and sold within the territory are consistently and reliably high quality. O, eligibility requirements to apply for or hold a standard cultivation license, micro cultivation license, standard processing license, and micro processing license for the purpose of ensuring, among other things, that all facilities to be used by license holders have been inspected, certified, and licensed by the appropriate health and safety authorities. P, procedures for addressing accusations that a license holder has breached the provisions of this law or the regulations, and if finding of culpability is made, sanctions that may include suspending or revoking the license and the imposition of fines up to $100,000 per breach. Q, the maintenance of public order, security, and safety of persons working in and for customers of dispensaries. R, processes and systems that cultivators, processors, distributors, and dispensaries must use to ensure that 1, cannabis is safely handled and stored. 2, cannabis is not sold to anyone who has not attained the prescribed legal age. 3, no person can purchase an amount of cannabis that exceeds the amount prescribed by the regulations from a dispensary or a combination of all dispensaries in the territory. 4, the board can accurately track all cannabis sold by a cultivator, processor, distributor, and dispensary, and the price at which the cannabis is sold. 5, dispensaries distinguish between sales to Ungwahue and non-Ungwahue consumers. 6, the board can accurately verify that all mandatory community contributions and all point of sale fees have been charged, collected, and remitted as required by the law. S, the maximum and minimum prices for which any cannabis product can be sold by a cultivator, processor, distributor, and dispensary. T, the percentage that will be used to calculate the point of sale fee required for dispensary sales to non-Ungwahue consumers. U, the definition of public area for which purposes of this law and the regulations. V, the definition of buildings or areas as the phrase is used in paragraph 17.1a of this law. W, advertising and marketing that license holders may or may not conduct. X, packaging and labeling requirements, and Y, any other regulation necessarily required to achieve the purposes of this law.
Section 8, review. 24, review. 24.1, a decision by the board may be reviewed by the administrative tribunal in accordance with the Kahnawake Justice Act and its applicable regulations.
25, enforcement. 24. 24.1, the breach of this law or the regulations, if the breach is regulatory in nature, will be addressed by the board in accordance with the procedure established by the regulations, and if a finding of culpability is made, will be sanctioned in accordance with the provisions of this regulations, which sanctions may include but are not limited to the imposition of a fine and the suspension, amendment, and or revocation of a license. 24.2, the breach of this law or the regulations, if the breach is criminal in nature, will be investigated by the Kahnawake peacekeepers, and, where appropriate, criminal proceedings will be initiated and adjudicated in a court of competent jurisdiction. 24.3, notwithstanding subsection 9.1 of this law, any person under the prescribed legal age who is found to be in possession of small quantities of cannabis or using cannabis within the territory will not be subjected to criminal proceedings under this law or any other applicable law, but will be provided the opportunity to attend a class or program established by the Cannabis Health and Safety Committee or by any other organization identified by the Cannabis Health and Safety Committee for the purpose of educating young persons about the risks associated with cannabis use.
Section 9, 25, concluding matters. 25.1, if any part of this law is found by a court of competent jurisdiction to be invalid, it may be severed and will not invalidate the law in its entirety. 25.2, this law comes into force on the day it is enacted by resolution of the Mohawk Council of Kahnawake. 25.3, this law may be amended in accordance with the procedures set forth in the community decision-making process as amended from time to time.
And that is the law, right then and there. We do have one more piece of business that we have to take care of, and then we will take some questions for the media.
Okay, so we have left here the certification of the process. It'll be signed off by Rhonda Kirby, the portfolio chief, Gina Deere, also portfolio chief, Vernon Goodleaf, KLCC community representative, Keisha Goodleaf, KLCC community representative, Dennis Dybel, the technician, and myself, Leslie Bova Skye, as the KLCC coordinator. So just quickly, would you like me to read this out?
Yes, please.
Okay, in the matter of the creation of the Kahnawake Cannabis Control Law, we, the Technical Drafting Committee, KLCC Coordinator, and the KLCC Community Representatives, do hereby certify the following. 1. This draft law, Kahnawake Cannabis Control Law, received its mandate from Chief and Council for its development on November 20th, 2017 in Kahnawake. 2. Chief and Council determined the scope as being create a framework and establish a licensing process within which the production, distribution, sale, as well as the possession and use of cannabis within the territory will be strictly regulated. Harmonized the licensing process for the production of cannabis in the territory with the production licensing process overseen by Health Canada. Establish criteria of the eligibility of distribution and licenses. Establish a regulatory body to be appointed by Chief and Council, mandated to regulate all aspects of the Kahnawake industry, cannabis industry, in the territory in strict accordance with the requirements of the law. And ensure that the community receives tangible socio-economic benefits from the proceeds received from any cannabis industry operating within the territory. 3. Chief and Council approved the purpose as being to ensure the health and safety of the community first and foremost. 4, the final law does faithfully reflect the purpose of the law as contained in the initial mandate received from the community. The development of the final draft law has, in all respects, conformed to the community decision-making process. This law has been brought before the community and read into the record on December 4th, 2018 in Kahnawake. Okay, that's done. Thank you.
That's done, and at this point, we'll sign it, and while we're doing that, I imagine we can then take some questions from our local media. So this will take only a few more seconds, and I know, Paul, you're in a bit of a rush to get back.
This is pretty important. I think
Yeah.
we'll stay and
Okay.
exhaust as much as the questions as necessary. Yeah, it's almost 11 o'clock now, so. Just for everybody out there
Dennis,
tuning
if you
in on
can-
Facebook Watch, 1037 is here at the formal reading of the Cannabis Control Law in Kahnawake. And it's time for question period.
And we're just about signed off. Okay, Paul?
All right, if I may go, first off, this obviously is a closed reading, pretty much. I mean, people could have called you, Joe, earlier if they wanted to be here today from the community, and people want to know why this is a closed hearing. And in that explanation, why not just have security present based on how the last couple of public meetings have gone?
Well, it's actually based on what has happened in the last couple of meetings. We've had comments from community members about their own safety in the meetings and their inability to ask questions, feeling that they would be ridiculed by some of the other community members who were at the meetings. We've had very lengthy discussions after each of the meetings that we've had in the last few weeks about the behavior of some of the individuals, and we felt it was important to provide the safety measures for others. And today is the official reading. It's not, we've said it time and time again, we're not at that point of having a debate at any of these sessions, and this is the formal reading. So it wouldn't be, if anyone did, yes, you're allowed to come and view the reading, but it's not a point of having any further discussion.
Yes, and just further, in the past, when we've had the readings, people were able to ask a few questions and get some clarifications, and in some cases, may have noticed the need for a comma here and there, or minor changes, but the law is no longer open for debate at that point.
But have you ever done it this way before? And if not, I had asked them if you can address the issue of security, having people present for a public presentation.
Well, I think even if we had security and if there were people there who were against this law, it would have been a disruption to the reading of the law.
Okay. Now, about this law, how do you explain the difference between this and the alcohol law in the community? What are the major differences between the two that you can come up with? I'm hearing 21 for this, 18 obviously for alcohol, but are there any other major differences? Tax, which was not called the tax in reading in points 21 and 22.
It's a royalty. Yeah. Well, I think with each law, we learn a lot. The community is changing, and I think those are some of the things that we've taken into consideration over the last few years about how things around our community are changing and that we have to adapt. So the considerations are made accordingly for each law.
I think something that's important to mention is that you have to look at how the community has developed. Historically, for example, you mentioned the alcohol law. The alcohol law, for years, alcohol was, you could buy and drink alcohol. You just couldn't do it on the territory except within the certain, the clubs in town had an agreement, and, you know, that was allowed. It took a long time for the community to finally say, okay, we can have places where it is sold. So that law was developed under different circumstances. I think this one, there was a lot more consultation, and I know some people were saying that, well, there wasn't enough. Well, there was 2 years of it, and I know how, you know, people tend to get excited at the last minute as things get closer. But there was an awful lot of consultation. Number one, a lot of what is put in here, especially when you talk about a communal benefit, that was because of the consultations that took place where people were adamant that they wanted the community as a whole to get something and not just individuals. Because you have to balance off, there's nothing wrong with people making money, but so many, you know, not only the people who are within the industry, you know, the community members wanted a communal benefit as well. So that's the work that went into balancing this. I don't think that is included in the alcohol law, for example. That's just a straightforward law.
You had mentioned it as a royalty, Rhonda, and I'm just curious, do you have a number in mind, a percentage in mind, and for both non-ongoing and for in the community? And does that, or will it be amended for the alcohol law as well? Does it apply?
Well, I don't think it'll, it certainly wouldn't have to amend the ABC law. I mean, this is strictly about the cannabis law. No, we've also mentioned that before, that even though this law is in its final stages and looking to be enacted, it's still going to be several months before there's the regulations are made. It's a phased-in approach, you know, creating the Cannabis Control Board, the terms. So there's there's still considerable amount of work that has to be done before we get to that point of recommending a set price.
Okay, you're gonna be creating a cannabis control board once you enact this law. How are they gonna oversee, since they're an arm of, but at arm's length, as you had mentioned at the beginning, at arm's length from the MCK, but still appointed by the MCK, how are they gonna oversee the potential deal that, you know, you've signed that letter of agreement or understanding to explore with Canopy? How are they gonna oversee you guys without it being a conflict of interest?
Okay, so it's certainly in lines with what we're doing with the Gaming Commission. And for the Canopy thing, nothing is finalized yet. We are still looking at, you know, the possibilities, but nothing has been signed officially with them.
But it's still, it's almost an apparent conflict of interest if you have a board assigned by the MCK overseeing an MCK business, is it not?
Well, we're going to run it like we talked about, the similar in the lines of the Gaming Commission, what goes on.
Okay, and if MCK gets into the business of production and possible sale in the community, you'll be subject to the same royalties, as you say?
Of course.
Plus, I mean, all the money goes back into the community anyway, right?
You know, I mean, I think if you've been here long enough, you see the amount of activities that go on, the amount of fundraising that goes on in every different area, for young children up to the seniors. So there's a lot of unfunded activities that go on, and I think it's the responsibility, and certainly not the responsibility of community members to always be funding those things. I think people are very happy to participate in that type of thing, but it is also the responsibility of the Mohawk Council to ensure, you know, the health and safety and security, and that our people are living well in our community.
Essentially, you had mentioned the age of 21, obviously it's 18 in the rest of the country. Who's it going to be up to enforce that? Is it at point of sale? It's up to the retailer to make sure that people provide identification?
And you know, that recommendation came from the Director of Community Services, and also a recommendation from Dwayne Zachary of the Peacekeepers. So, you know, there were a lot of consultation that had gone on. We've taken a lot of those things into consideration, and especially that from community members who, once we had the law posted, the the draft law posted, they had an opportunity to give their comments, and those were incorporated where and when it was valid.
Yeah, there was a good question on the 21 because at the last meeting, the last first hearing meeting, Dale Dion actually mentioned how much work she put into and comments into the draft law when it was first out there about the 21 and the safety aspects. And it's kind of I think I was somewhat pleased when Quebec, at a certain point when the new government came in just a few weeks ago, one of the first things they said was, well, we're considering looking at 21 as well, because we've said all along that the Kahnawake Cannabis Control Law is for health and safety more than anything else, because you have to make sure that, you know, it does things to protect people. And one of the big issues is the developing brain. And like Rhonda said, when the director of Sugotiat the Genhas, in some of the meetings, the public meetings that were held, it was very, very passionate, and really people were impressed by what he said and understood, because there was a lot of debate about the 21, because like the peacekeepers, if you arrest somebody who's smoking in Kahnawake and they're 21, what can you do about it at this point? That's why you see in the law that it's understandable that it's not going to be a simple matter of fines and things like that. It's really going to be about education more than anything, because of the conflict of the laws that are out there, and people are going to use that to their advantage. So, you know, there was a lot of discussion and debate.
You had mentioned a small amount in the reading a while ago for possession and dealing with this kind of situation, Joe. I'm just curious, what constitutes a small amount? Is it 30 grams? Is that the number that, you know, that Canada follows?
That's what is normally allowed now, is 30 grams. So again, we're still going to be looking at all of those that are mentioned here in the law.
So from the last meeting, where the law was read out, to now, we're just read out the final draft. What are the major differences in the laws? Have there been any major changes made based on feedback from the community?
No, I wouldn't say there are any major changes. I think from the last meeting that we had on November 20th, although your paper had mentioned that a lot of people were against it, I think there were a few people who were very vocal that were against it. And there were people there who also were for having a
That's
law.
not my question, though.
Yeah, but there's nothing changed. Nothing has been changed. If anything, grammatical, you know, commas here and there, but we haven't changed anything.
The Mohawk Council has said from that meeting that the comments that were made from the community at that meeting would be taken into account and then would be made
Yeah.
into the final version.
There might have been a couple. I can't, you know, I can't think. I know there. I think there were two. And one of the things that a community member had said, that there were too many organizations that were involved in the health and safety, and that hasn't changed. We think it's important. All of those organizations have been part of the drafting committee all along, so we're going to be keeping those organizations on.
There was one thing that came to mind as I went through the law that I noticed was changed. And by the way, the law is posted on the website, and it does have this version, but it also has the one with the track changes, so people can see what was added and when it was. So that stuff is there. But one in particular, because it wasn't answered, and that's part of the problem we had with the last couple of meetings, is with the disrespectful behavior, sometimes questions came that nobody had a chance to answer because there was too much going on, and opportunity wasn't given to answer. But there was one community member who did say at that point on the safety commission that internal or could be from outside the community. And even though the intent was that it could be, say for example, there was a First Nations cannabis health group, they might be asked. But it was felt that for the purposes of the law, just take out the external, because you didn't want to give any kind of ammunition that people might think that the RCMP or somebody is going to be asked to be participating, but basically it's under our control. But that was taken out because of that. It wasn't answered at the time, but if it had been, that's what it, you know, it was addressed there. So that one for sure. But there were a couple of others that were there, mostly small stuff. But there was also for the community member to be voted onto that committee as well. A community member would be given the opportunity to be elected there. That was another one.
How do you make this enforceable in court, and which courts are we talking about here?
Well, like I mentioned, it's still a few months away, and we have time to collaborate with the chief peacekeeper here to see how things will play out. We know we're still working on the Justice Act, and that's been taking a lot longer than we thought, but there are meetings going on to see how and make sure that what we're doing is beneficial to our community.
Also, a question about the cost of testing that was also mentioned in the reading. Who pays for that? Who does it? Obviously, I would imagine there's no real way of setting up the testing of the product in the community. Are you planning on setting up a testing center?
Well, it's not a testing center. Once a license is given or the application is made, I mean, there's quite a few steps before the license is actually given out. There's a testing phase, so it would have to be somebody from Health Canada at this point who would come in and test the product. And eventually, we would train community members to be able to do that process.
One thing that came out of the information sessions is we do have community members right now who have a license, but they're operating outside the territory. And a lot of information was gathered in those community meetings and those info sessions. And one person in particular had a lot to say about at a certain point. They were adamant that right now we can't do it properly, but they would love to, and they had one of their people going to school to learn how to do it properly and get all of the proper paperwork, because again, health and safety, you can't just pretend you know what you're doing. You have to know what you're doing in order to do proper testing so that consumers are getting a safe product. But there's been a lot of talk, and again, there are people within the community who have a lot of knowledge about an industry that is still really in its infancy, and we have to do it right.
Finally, for me anyway, just to be clear, you must have obviously a license through the Cannabis Control Board and through this law, but also through Health Canada in order to operate in the community.
And we've always talked about the two-tiered licensing system all along.
Okay.
Anything else? Lachlan, you have anything
No,
else?
good.
All right, so
One more
Leslie?
thing before we're done. I misread something here. That was number 4. The final draft law does faithfully reflect the purpose of the law as contained in the initial mandate received from the chief and council. Thank you.
all right, thank you. So at this point, Rhonda, I guess the final legislative part anyway, this will be going back to chief and council for final signature.
That hopefully we'll be doing that next Monday. And again, I'd like to thank the participants of the KLCC for helping us along in this process, and for community members who have come out to our meetings over the last 2 years and stayed in tune to what we're doing. And again, it'll still be several months before anything is actually ready. But we're all willing to work very hard towards that completion.
All right. Well, thank you very much, and thank you for viewing. See you next time. I want to give one.